It is my honor and privilege to introduce to you today Mr. David Ekanem, an associate with Stream Sowers and Corn. So I'd like to give the floor now to Mr. David. Thank you so much.
Okay. Good morning, everybody. Can you hear me?
Yes, sir. We can hear you, sir.
Okay. I'm happy to be here and to meet everyone here present. As he said, my name is David Ekanem, and I'm a lawyer. And yeah, it's great to be here to talk on trademarks in Nigeria with you guys, so you know the processes that are involved in terms of registration, infringement, and how you can enforce your trademark right where it has been infringed on by a third party, right? And how would you also know the infringement? So we'll just get started. Mr. Onome, can you share the presentation so we can just get started?
Mr. David, can you give me just a few seconds to load that up?
Okay.
In the meantime, can you just tell us a bit about yourself? I know I gave a full profile.
Okay, guys. So, well, I don't know what Mr. Nome wants me to say more, but yeah. So, I'm a lawyer at Stream, so I'm an associate at Stream, so as I'm Corn. We're a Nigerian law firm. So when you hear the word Corn, it doesn't mean we are maybe a German law firm or something. We are based in, Nigeria, and well, we seek to expand into West Africa and beyond. Anyway, so I'm more into, dispute resolution, corporate commercial practice. And under the corporate commercial practice, I look at technology law, business insolvency, and also artificial intelligence governance and policies, right? So it's a privilege to be here. And when I see when Mr. Normi told me that this was going to be about startups and entrepreneurs, I said to myself, okay, this is an opportunity for me to also interact with startups and business owners, right? So because a lot of times the startups do make some small mistakes, right, I would say, and it goes to affect how they can run their business and stuff. So today we're going to be very, very well, we're going to be fast a bit because I had to bring in a lot of information, and I was told to just have an hour to do this, for 45 minutes, sorry. But let's say within that time we're going to have a lot to discuss, and then I'll take your questions, and then we can proceed from there. So please, in the meantime, can we just mute ourselves so we don't cause any sort of interference? So please, let's just mute our mics, and then at the end of the session you can unmute mics, right? So I think we can move. Yeah. So today's topic theme is trademarks in Nigeria and registration, infringement, and enforcement. Right. So please, next slide. Yeah. So in content we're going to be looking at today will be what is intellectual property. Right. We're going to start with that basis, so we'll know where trademark comes from. We're going to look at the types of IP, that intellectual property. Then we're going to look at trademarks, the relevant legislations on trademark, purpose of a trademark. Then we look at the registration of a trademark, trademark infringement, trademark enforcement, how to protect your IP, right? And just a bonus, I just had to put that in there for startups and. Okay. Can you hear me now, right? All right. So, next slide. Can you just see the next slide? Okay. So, what is intellectual property? So, according to the World Intellectual Property Organization, WIPO, intellectual property refers to creation of the mind, such as invention, literary and artistic works, designs, symbols, names, images, used in commerce and any other aspect of life. I mean, essentially, intellectual property is about protecting your ideas, your innovation, your creative expression from people or from organizations, infringing on that right. So it helps uh, protect a kind of unauthorized use by a third party. So let's go to the next one. Then we have the types of intellectual property. We have the copyright, we have trademarks, we have patents, we have industrial designs, and we have trade secrets. Now, the essence of today's workshop is for us to just look at trademarks. And while we have different procedures for copyright, patents, industrial designs, and trade secrets, today we're going to be looking at strictly trademarks, right? So let's move. We're going to be fast a bit. Okay, so what's trademark? According to the Trademarks Act, it's any device, brand, headings, label, ticket, name, signature, word, letter, numerals, or any combination thereof that indicates the source of origin of the goods and services. Now, before now, trademark only identified goods, but by the advent of the Business Facilitation Act of 2023, services was added to also form part of the definition of a trademark. So you're not just only trademarking your goods, but you're also looking to trademark the services you render, the services that makes you stand out. You understand? So a registered trademark is a property right whereby the owner is granted exclusive right in relation to use the trademark, right? So once you register your trademark, you have exclusive right over that mark, over what you use that mark to do in terms of your business, in terms of what the public sees about you, in terms of your services, right? And most of the time we see that the registration of the trademark R grants a monopoly right to the proprietor, that is to you who have registered, and once registered can be protected under the statute and under common law, right, of passing off, right? So we're going to look at where passing off comes in the course of this um, workshop. And then when you see TM, it stands for unregistered trademarks, and you still can enforce them under common law of passing off. Yeah, it's recognized in our jurisdiction here in Nigeria. So we will also look at that in the course of our presentation. So next slide, please. So relevant legislations include the Trademark Act, the Trademark Regulation of 1967. Sorry, it's old, but I mean, we hope that a legislature would do something about it. The Merchandise Mark Act, we have the Trademark Malpractice Miscellaneous Offences Act, we have the Counterfeit and Fake Drugs and Wholesome Processes Food Act, and then we have the Cybercrimes Prohibition and Prevention Act. So we're going to see where all these acts comes into play when we're talking about, enforcement and registration, making an opposition to the registration of a trademark. So we'll see all of this. Next slide, please. So what's the purpose of a trademark? Now, we may say, I mean, what do I have to register a mark, an insignia, a symbol of mine? I mean, why does Apple, Microsoft, I mean, Samsung, other brands, why do they have to register their mark? So it's something that makes you stand out. It's to protect your business brand and prevent confusion in the marketplace. So if you have a very distinctive mark, let's say, for example, I'm seeing maybe Abigail here. Abigail has a very exciting proposition into cosmetics or skincare, and her insignia is ABY, ABY in a very designing format. And people get to use ABY cosmetics because, I mean, or skincare product, because it has a way of making the face shine. I mean, everywhere we now see, oh, ABY cosmetics, exciting. You understand? And you know, and another time we have Ayomide. Yomide comes up with another skincare fantastic idea to make the skin glow. You understand? And for you to have a distinctive, mark, you have to actually ensure that you put your mark out there to say, oh, this is ABY, because somebody might want to go and buy ABY, and Ayomide has her own brand that makes the skin glow, and has his ABY as well, or AYY, right? But what will have to be is that that insignia, that mark, or that name will have to be considered, so it does not cause any kind of conflict, any kind of confusion, so that somebody that wants to buy ABY will not end up buying AYY. You understand? So that is where the concept of the purpose of registering your trademark comes in, and it establishes a unique trademark. A business can distinguish its product, by establishing a unique trademark. A business can distinguish its products or services from those of its competitors. So in today's workshop, we're looking at Abigail and Ayomide as competitors. So please, I know you guys don't know each other, but just for the purposes of this workshop. Okay, so next slide, please. Yes, so the trademark that you cannot register, involves a mark that is deceptive. It's scandalous mark, or it's a scandalous designs. Marks that can, are likely to cause confusion, as I earlier stated. So, names of chemical substances and geographical names, or in the ordinary significance, are also ineligible, for trademark protection. So you have to ensure that it's not deceptive. You don't want to, or because Apple, the person that end up biting Apple just bit so much into it, and you want to make your own design to be like a very small bite. So you don't try to make it deceptive that, okay, I want to go into skincare, and you end up doing something quite illegal with that trademark. So you end up deceiving the public about what you do, but you end up doing something quite strange. So, and scandalous, some immoral or illegal signs and stuff. So that's what you cannot trademark. Okay, so next, please. So, right, so we're going to go down into registration of a trademark. Okay, so in the course of talking about this, we're going to talk about other things. So let's move. Yeah, and yeah, so the trademark is registered through the Trademark Patent and Design Registry, Commercial Law Department of the Ministry of Trade and Investment. It's not in any other place. You cannot go and register your trademark under copyright or trademark under your patent. So trademark is under this body. So please take note. Next slide, please. Now, also, please let me bring a disclaimer, please. The pictures you are seeing here attached to these slides from now on are artificial intelligence generated pictures. They are not any existing human beings. They are generated by Meta AI. So I don't claim drawing that myself. So thank you very much. So what information do you need when you want to register your trademark? So as for Abigail and Ayomide, you would need the name, the nationality, an address of either yourselves of the trademark. Okay, so the word proprietor is you, right? And perhaps let me add a guy to this so that they will not end up saying, why is he only using females? I've seen Timothy here. So okay, thank you. So I'm going to also add Timothy to the list of those I'm going to be using. So Timothy, Ayomide, and Abigail. So you guys are proprietors, right? And so you will need to use your name, nationality, and address. Now, what are you going to use as a representation of your trademark, right? Is it going to be AYY or ABY, or are you going to use an insignia of T drawn in a very colorful, wonderful way? So a representation of the trademark, what are you going to use? Is it an insignia? Is it a letter? Is it an image, or what? Then specifications of your goods and services for which the trademark is sought to be registered. Okay, so we're going back to a representation of, okay, yeah, specifications, sorry. So specifications like goods and services. What do you want to do? Are you going to be doing what Abigail and Yomide are doing, cosmetics, skincares, right? Or do you want to be like Timothy, who is into hotel services. He wants to, he has an hotel that will be rendering services to people, or maybe a transportation service. You understand? Transportation or telecommunication. So you have to, specify. You understand? And then we have classes. So trademark is done vis-a-vis classes, right? So we're going to, look at it. We look at that as well as trademark classifications. We use the NICE classifications, right? It came by way of the NICE Agreement of 1957. It is recognized internationally, right? And it has about 45 classes, which we will also consider in the course of this workshop. So is it that you're going to classify your goods under goods, your trademark under goods or under services? For classes for goods, they're about class 1 to 34, and for services we have 35 to 45. So you can't put services under goods or goods under services. They have their classification. So we'll also look at that, and we'll see what kind of goods and services are going to be, classified. So next slide. Oh, hold on. And then, yes, an executed power of attorney in favor of an authorized agent or attorney to be filed at the trademark registry. So for you to register your trademark, you must pass through an authorized agent. That is somebody that is, certified to carry out these kinds of transaction. You cannot on your own wake up in the morning and get into the portal and register your trademark. No, you have to pass through an authorized agent. And in order for you to do that, you must execute a power of attorney in favor of that agent to say, oh yeah, go ahead, register my trademark for me. I have given you all the authorities and the power. So whatever information you need from me, I'll give it to you. So that is what Ayomide, Abigail, and Timothy were going to do as proprietors. So they will now contact who is here, maybe an authorized agent, right? And then a power of attorney will be passed, and there is a prescribed form for that, right? All right, so Ibrahim, please try and mute. Thank you. Um, then, so please, next slide. So, okay, so let's talk about the classification. So I think my Abumiti did in the slide. So based on the NICE classifications, which consist of 45 classes, right? Classes 1 to 34 covers goods and services. I'm sorry, class 1 to 34 covers goods, and classes 35 to 45 covers services. Now, what are the goods under, what are the classes under classes 1 to 34? We have chemicals, we have paints, we have cosmetics and cleaning preparations, we have fuel, we have pharmaceutical, we have metal, we have a lot medical apparatus, vehicles, firearms, jewelries, musical instruments, again, leather, we have furnitures, housewares, and glasses, fabrics, clothings, fancy toys, fancy goods, floor covering, tiles, staple foods, natural agricultural products and produce, wines and tobacco, spirits, there are a lot. So just whatever has to do with goods, whatever has to do with what somebody can buy, right? Somebody can use, you understand? The goods, that is what you can put under this. Now, for services, example, advertising and business services, insurance and financial services. We have building, constructions and repair services, telecommunication services, transportation services, education and entertainment services, computer and scientific services, hotels and restaurant services, medical and veterinarian services, personal and legal services. Yeah, you put them under classes 35 to 45. You understand? So with these classifications, you would know that that is what the registrar, when assessing your application, would look into. Does it conflict with any other class under these headings, right? Do we already have somebody who is offering hotels and restaurant services that is also with the same insignia or label that which Timothy has brought? You understand? So what do you do when you want to, the steps you need to take to register, your trademark? We're going to look at it from number first thing you have to do is you conduct availability search. So you don't just wake up, as I said, in the morning and, oh my God, this idea is so great, I want to register this trademark, I'm going to register everything about my business, right? First and foremost, you have to calm down, slow down a bit, and first of all, conduct an availability search, right? Before even applying for the trademark registration, you must conduct a search, and then you have to do this through your authorized agent. So whatever idea you have, you can now pass all that information as we earlier provided before, the information you need, you give it to your authorized agent. Now, first and foremost, a search will be conducted, not online, because I mean we do not have that database yet in Nigeria. So everything that has to do with search will have to be done at the trademark registry. I mean, we're getting there to having all of this documented on a set, so you can search. But for now, we don't have that, that technology for that in Nigeria. So a search will be conducted. Everything will be, to see if there is a similarity, if there is kind of anything that will cause confusion or whatsoever. And after a search is conducted and there is nothing found, and that name which you have provided, that's insignia or whatever symbol you've used, which you want to register your trademark, is deemed available. That is, the registrar will say, oh, there's no problem. That's nice. It's deemed available. What you will now have to do is that you're going to now apply and for that trademark to be filed at the trademark registry. Now, that application will now contain the name, address, that particular information now will now be filed, right, at the trademark registry. Yes. And then it will be examined by the registrar, right? To be examined to show that it does not conflict, it does not have any deceptive or any frivolous, scandalous, it's not illegal, it's not what should I say? It does not form part of any prohibited signs in Nigeria. You understand? So if it does, it will be rejected. So it's not contrary to law, immoral, deceptive, or scandalous. As I said, it's not meant to deceive or cause confusion. It does not contain chemical substances. So we just have to refer back to those categories of things. And it does not include the use of the coat of arms of the Nigerian flag or any emblem, that is related to the Federal Republic of Nigeria. And it does not contain the word patent, patented, or registered design. I mean, it's not also part of the Red Cross, Geneva. So those ones I've just mentioned, you will need their consent in order for you to put them in your insignia. So if you want the consent, if you want to use the Nigerian coat of arms or you want to use the Nigerian flag as part of your trademark, you have to obtain the consent of the president. You understand? And for the Red Cross, you have to have the consent of the Swiss Federal, Federation for you to do all of those things. So that was what the registrar will put into consideration when examining your trademark. All right. So, and after examination is done, and the registrar will now issue an objection, right? Or sorry, may issue an objection or request for additional information if there is any of those things I've said, if there is actually it can be recognized there. But if there is none, the next thing the registry will do will now to publish your trademark in a trademark journal. Now, once it is published, it is to call people, people out there, the public, to come and raise an objection to this. That thing we say during marriage, if anybody does not want this union to go on, this is the time to speak or forever remain silent. Now, this is the time. Thank you. Now, this publication will now be on the trademark journal, and it will call for oppositions and objections from the public. And this is to be done within 2 months. Right. It's to be done within 2 months. So after that, now by virtue of the provisions of the law, within that 2 months or 3 months, as the case may be, it will be there. Nothing, you just have to wait. You just have to wait patiently for this to be done. And for whatever reason there is an objection or an opposition, The provisions of the Trademark Act provides that, particularly Section 20, 125, and Regulations 45, 48 to 57, right, provides that, look, for you to oppose, you need to, first of all, let's say, for example, let me use somebody here. Who is here? Tracy. I can see Tracy, or who? Let me use Damilola. Yes, Damilola. For whatever reason, Damilola is not happy with Abigail or Ayomide or Timothy, right? For Damilola to oppose to the registration of the trademark, he has to file a notice of opposition, right, within 2 months. You have to file within 2 months from the date of the publication of that application to register the trademark. And you must include the grounds for which you are opposing that registration. Now, those grounds could go back to what we stated earlier about being scandalous, confusion. He's not going to use it. He's not the person that registered. In fact, it has a tendency of deceiving the public. It's very identical to the previously registered trade or famous trademark. It contains chemical substances. So those can be the reasons Damilola could bring. And upon filing the notice of opposition, the registrar will now send a copy of that notice to Timothy, Abigail, and Ayomide. You say, oh, there is an opposition. No, do you have anything to say? Now, they will now say, okay, the Timothy, Abigail, and Ayomide can say, yeah. So you have within 1 month to file a counter statement to the registrar and say, look, our trademark is not what he says it is. We have actually taken our time to distinguish that trademark. So you are also from your counter statement, you're going to state grounds towards which the opposition did not, or grounds to which the opposition is supposed not to be, that your trademark is clean, right? Your application is clean. So you have to file a counter statement within 1 month. Now, if you do not file anything, right? If you do not file anything within that 1 month, it will be deemed abandoned. That is, you are not proceeding to the next stage of your application because there is an objection against you going further. But if you do file a counter statement within the 1 month, the counter statement will now be sent to Damilola, who will post. Now, both parties will now do what we call exchange statutory declarations in form of an evidence that, okay, this is what we have, this is what we can, this is the evidence we have, and we're going to tender, we're going to do it at the hearing. The registrar will now fix a date, and then hearing will be done. Damilola will present her point or his point. Then Timothy, Abigail, and Ayomide will say, look, this is our position. And the registrar will now give the decision. Now, if the decision given by the registrar is not very comfortable with parties, right, you can appeal to the Federal High Court. The Federal High Court has jurisdiction over trademark-related matters. So you go to the Federal High Court, and that is how it is. But let's say that everybody is happy, we are all friendly neighbors, and everybody's so happy together in this place. And there is no opposition by Damilola. So what happens? The next thing is there will be an issuance of certificate of registration, right? So where there's no opposition, issuance of certificate comes into play. And then the registry, as I said, will issue a certificate. So this process, all this process we're talking about that I use about 5-10 minutes to talk about, of registering your trademark, could take up to 12 to about 18 months. So it's not a thing that takes 3 months or 6 months. It's about a year to almost 2 years, right? 12 to 18 months, depending on factors. Depending on the number of objections you may get, and so this is where you also need to involve your legal practitioner. You need to involve a lawyer in all of this. You understand what I'm saying? So it's not something that takes 3 months or 6 months or 12 or 1 month to do. So we've discussed trademark classification. So next slide, please. Yeah, so please take note. This is very important. The proof of use of of your trademark, of your mark or whatever, is not a ground for renewal of your trademark in Nigeria. So after you register, after you've been given your trademark certificate, it takes 7 years before it expires on the first limb. And then once you renew it, it takes 14 years in perpetuity for you to renew. So after the first 7 years, once you renew it, you renew it again in 14 years. And after the expiration of that 14 years, you renew it again to take another 14 years, and so on until you are no more. Please, you understand? Until the business is no more. So trademark registration and protection are territorial. So please, once you register your trademark in Nigeria, you cannot say that that trademark is going to be the same with US, UK, Canada. Your registration is in Nigeria, so it's territorial. So whatever a business you want to go and do in Canada, you also have to present the one you've registered in that jurisdiction for consideration. So a trademark can acquire distinctive character through the use and adoption or adaptation. You understand? And before a trademark can acquire such distinction and character, the mark must be capable of creating an association in the minds of the purchasing public, of a connection in the cause of trade. So what this grammar is saying is that, look, for it to have an appreciation, people will have to know that, oh, that is Dangote spaghetti, and that is Golden Penny, or that's pig milk, that's cowbell, that's what other milk do we have? We have Dano. So people must have to understand where these insignias. If you see Dano, you will know this is Dano milk. If you see pig milk, oh, this is pig. If you see 3 Crown, this is 3 Crown milk. So everybody appreciates that use and adaptation. That is what this grammar is. And then, as earlier said, power of attorney is needed for you to proceed to do with your agent to do your registration. So please, next slide. Let's move. We're behind. Yeah, so grounds for refusal, as I said, this is where I had to bring it in. So where it's bereft of distinctive character, right? You're just confused like an amoeba. I mean, what do you really want to do? What does it mean? What does it stand? What as it doesn't stand out, so it can be refused. It's contrary to law, or it's immoral, deceptive, or scandalous. It's likely to cause confusion, or the name has content of chemical substances. You use the Nigerian coat of arms, and you're using the Nigerian flag or colors. You need consent for all of this. So I've already discussed this. So let's move to the next slide. I hope you guys are enjoying the pictures I also use. I mean, these are AI pictures. They all look so cute. Okay, so please note that the refusal to register a trademark can be appealed to the registrar of trademarks, right? So if they refuse to register your trademark, you can appeal. In the course of registration, you can appeal. And then the time frame for the appeal, this one is not opposition. This one is the registry themselves saying, the person in charge say, I cannot register your trademark. So you will now come by way of formal application or formal filings to say, look, tell me the reason. No. So the filing of the appeal is to be done within 2 months from the date of the refusal, and there is no cost. You don't have to pay for anything, right? And the time frame for receiving a review of the appeal is 3 months post the filing of the appeal. That is, after you've applied, you're to get a review within 3 months, right? After you've applied. And the decision, if you're not comfortable with what the registrar is going to tell you, you can now further appeal to the Federal High Court, right? So next slide. So duration, I said it, 7 years from the date of filing. It goes back. So once you are given your certificate of registration of your trademark, it doesn't take the dates which you have been offered. It goes back to the day you applied. So let's say you registered on you applied January 1, 2024, let's say 2023, and you got your certificate in February 13. I don't want to use 14. February 13, 2024, or 2023 or 2024. So it dates back to when you applied in January 1, right? You understand? It dates back to January 1. So thereafter, you can now, renew in perpetuity every 14 years after the first 7 years. So to renew an application, you have to make it to the registrar through appropriate form, along with that certificate of registration which was issued to you, and then you can, renew. Now, if you are late, yes, if you miss the date of your renewal, or maybe it has expired after 7 years or after 14 years. So what you now have to do is to ensure that you pay prescribed fees or penalty fees for late renewal. Yes, you can renew. You can renew even after 6 months, if after 1 year. But the thing is that you have to pay default fees. So you have to also put into consideration your date of registration so you don't miss out. Or if you have the money to pay for late fees, because the registry will be the one to give you that fees to pay, you will pay it. But definitely you will renew your trademark. Okay, so next slide, please. Yes, so yes, your trademark can be revoked. I mean, it can be registered definitely, but it can be revoked. So the grounds is for that. Number one, non-use. So when Ayomide, Abigail, or Timothy having registered their trademark and they don't end up using it, right? And you've not used it for even up to you've not used it for 5 years. So let's say you had a very bright bulb on your head when you were thinking about your business, and all of a sudden your interest just died out. I mean, or another thought came into your mind, or the japa took over your your mind, and you just decided to drop the whole thing. So after 5 years and there's no sign of it, please, Albert, can you mute, please? Albert, thank you. And there is no sign of your business, your whatever you wanted to do coming to play within 5 years could be revoked, because I mean, no sign of use been seen for non-use. Understand? You refuse to renew your trademark after a while, right? So you have to be very attentive. Now, where you obtain the registration fraudulently, right? That can be revoked, and where the trademark is likely to cause confusion, is scandalous and contrary to law and morality, and where the trademark is not distinctive, or is too generic, or is registered in error. So most times, we're all humans. Most times, registrars can actually register a similar thing. You understand? We're all humans. But for this to happen, there is always a way out. There's always a way out. So, that's that. So the next one is trademark infringement. So when can you say that somebody's infringing my trademark? When can a big girl wake up and sprang up and Yomide, come on, who is using my trademark? I mean, you're passing along Lekki Ekpe Expressway, or you're passing along Third Mainland Bridge, and you're seeing your logo in another person's product, or your stuff, or your services, or your kind of services in another person's company. I mean, we all know how these things work. So how do you identify infringement? So infringement occurs when another party uses a trademark registration without permission. So when you see, you won't see Three Crown use an insignia or trademark of peak, right? Let me even use a clearer example. For those of us who are into the AI space, there is a lot of trademark issues and debates between Meta AI and OpenAI, and maybe Mark versus Twitter, or Elon Musk. Elon Musk and Mark Zuckerberg. So there is a bit of an issue that, oh, look, Mark, why are you using the exact thing Elon Musk is using in his X? You understand? So Mark tried to bring in Thread to look like X, but that kind of back and forth, and they're going about it. So picking up things that are specific to a particular organization, and then you're using it to yourself without seeking the consent of that person, is more like an infringement. So you understand? So this is how this thing goes. And what remedies can you get if you file an application? You seek to enforce and protect your mark, right? So at the end of the whole proceedings, what the court will give you would be injunctive relief, damages to an amount, and seizure of those infringed goods, right? So let's say somebody's using your mark to go and, okay, let's say Abigail's Cosmetics and Skin Glow. Somebody's using Abigail's own, Yomide's own, or Timothy's services is being used by another company. So what the court will do is to write a cease and desist first. If the person refuses to cease and desist, from using your services, you can now go ahead and enforce it in court. So what do you have to do for goods that are being used, like for Abigail's Cosmetics and Skincare Glow? You can order for that goods to be seized and returned to you because it has what belongs to you in it. You understand? So that is how it works. Next slide, please. Yes, trademark enforcement. Yeah, this sounds exciting, but if you look at it from a very please, the man is. I'm not trying to say that anybody is a criminal, but let's just look at it from the perspective of what the picture says. I mean, you could be arrested in terms of crime because I've cited some the FCC spots here. So, a trademark infringement action can only be brought with respect to registered trademarks. So you cannot sit down in your house and draw something and your friend comes and sees it, takes that trademark, registers it, right? It belongs to your friend. We'll talk about that later. When you've not end up using that trademark. So you have to be very wise when you're building your plan and know who you discuss your business plan with. Right. So it can only be brought with respect to a registered trademark. The Federal High Court has exclusive jurisdiction over trademark matters. So what does the FCCPC, that's the Federal Competition and Consumer Protection Commission, have to do here? Now, when it has to do with the goods and services, right? Trade, manners that you offer your services, offer your goods to the public. Now, the FCCPC prohibits any undertaking from knowingly applying to any good a trade description that is likely to mislead customers or remove or obscure a trade description or trademark in a manner that is likely to deceive the customers or consumers. So, upon obtaining a warrant, they can conduct a search to be conducted, and they can seize those products. As I said, 3 Crown milk using pig milk, you are going in there to deceive people. You're deceiving the consumer. So when FCCPC obtains a warrant, they can come in and seize all those products, right? EFCC too has a role to play when you're economic and financial crime, to include theft of intellectual property. When you steal somebody's intellectual property, EFCC will come after you. It's not only money. So they are empowered to investigate such crime. Next slide, please. Yes, so regulatory bodies like NAFTA, Standard Organization of Nigeria, the Nigerian Customs, even our Nigeria Police, you can conduct investigation into cases of counterfeitings and also conduct such raids and seizure of infringing products. So fake malt, fake currencies, fake drinks, fake alcohols and spirits, these are all infringements. And to an extent to which is done, you can bring in these law enforcement agencies. Now, we cannot just look at it from the perspective of goods and services. We have online, social media, online activities, websites, and the stuff. So when there is an infringement when it comes to online infringement, a trademark owner can also approach and seek assistance from the Nigerian Internet Registration Association on abuse and bad faith registration with the domain name of the person. So Ayomide has exciting and excellent offers on her website, and she shares her website with people to say, come and purchase my product on my website. And she doesn't know that there is somebody out there, right, who has also done Ayomide dot something something and ends up also displaying those kinds of products, so it's more like distracting or deceiving the public that Ayomide has an extensive domain to another place, which is not proper. So what Ayomide can do is to go and meet reach out to the NIRA, and an investigation can be done. So okay, so before I talk about the civil procedures, right? Let's look at the criminal liabilities associated with trademark infringement. With respect to the Merchandise Mark Act, it criminalizes the trade description related offenses such as forgery of a trademark, false applications of goods of any trademark or marks so nearly resembling a trademark to be, and in the calculated attempt to deceive somebody. So if you are caught, if you are caught, you are liable for 6 months and a fine. And if convicted in proceeding before the Federal High Court, the offender is liable to imprisonment for 2 years or a fine. or both. I'm gonna have a wonderful time at Creek prison. But please, let's not do that. Then we have the Trademark Malpractice Miscellaneous Offences Act that criminalizes labeling and packaging. So sell or advertisement or of a product in a manner that is false, misleading, or likely to create a wrong impression as to its quality, character, brand name, value, composition, merit, or safety. Any person convicted is liable to a fine of not less than 50,000. Right. So, remedies. Let's see. Okay, yeah. So before we go into remedies, let's look at the civil ways this can be done. So if you find out that your let's say let's go to court now, right? Let's go to court. Let's say we've reported this issue to law enforcement agencies, and they've done their bit. Let's go to court now, right? So as Ayomide herself would want to go into enforcing her trademark right over AYY and Abigail AYB or APY, right? What you would do is to file what we call a writ of summons, right? You attach a statement of claim, you attach written statement on oath, document to be relied upon. And since the Federal High Court, you also file an affidavit of non-multiplicity of action, which means that I've only brought this action before the court alone, and I've not filed it any other place, or there is no appeal pending somewhere. This is the first time this matter is coming before the court. So your statement of claim will state how you got to get you have a chronological summary or description of your trademark, the story behind the trademark and how you got it and how you found out about the infringement. And then you're going to claim that the court should order a perpetual injunction for the person to stop using your trademarks, your marks, your insignia. The person should damages for usage. If the person has made money using your trademark, you can ask the court for damages to that extent. So the person will now calculate whatever profit he or she has made and still give it to you. So those are the things you would file, and you also attach exhibits and documents. Those are documents to be used as evidence. So with all of this, the infringer or the person that is infringing on your copyright, or sorry, your trademark, can also file a statement of defense. You can go back and forth, and from exchange of pleadings, you have now go to case management conferences where you have to talk about maybe try ADR, in the process. If it didn't work out, you can now still continue. Right. So what we should know that when you're going to court, it doesn't start and end immediately. It can take years, can take months. Well, if it doesn't even have interlocutory applications, right? If it does, there is no applications in between. When you say, oh, the court does not have jurisdiction, or there's no cause of action, or there's all those interlocutory application can take months for the court to hear. Coupled with holidays we have within the calendars, coupled with judges conferences, coupled with maybe situations in the country. Courts do not sit all the time. So in this regard, you may like to go for ADR, alternative dispute resolution. You understand? But if you want to go to court, fine. I mean, some people are always excited going to court to enforce their trademarks and stuff. But just know that it doesn't start and end immediately. That's what I have to tell you there. And what kind of injunction can you or file? You could have interim injunction. So interim is that saying, look, the subject matter here is very vital. It could be granted ex parte, which means the person infringing Ayomide's trademark need not be in court. So the court will grant that interim injunction to stop the infringer from going about with the trademark as if it is our own. And when an interlocutory injunction is also granted, it will be to keep that subject matter, the trademark, on hold till the court resolve as to who owns the intellectual property, the trademark itself. So this process also applies to other intellectual property types. You understand? So and then you can also compel a party to bring out documents in his or her position. We call that interrogatories. But let me not confuse anybody here. What I'm just saying is that you can enforce your trademark decision or trademark right in court. You understand? Or you can subscribe to alternative dispute resolution. That's all on you. That's for you to decide. You understand? So Remedies available for trademark infringement: I said damages, punitive, special or general, injunctive reliefs, interlocutory, interim or perpetual. Order for account of profits, as I earlier said, recover all the profits made from unauthorized use. You're delivering up of all the infringed products, and payment of cost. Right. So next slide, please. Yes. So so how do you protect your IP? I just brought this in as more like a bonus, So you have to register your IP rights, right? And then with the relevant regulatory bodies. Now, always use your IP symbols and notices, to show, oh, this is patented, this is trademarked, this is copyright, it belongs to me. So people would know that, don't joke with that guy. He has trademarked his stuff. And then keep records and documentation to whatever you're doing. Keep records. It's very important. As a business owner, you need to keep records. As a startup, you need all your documents in one place. You understand? You have to monitor and enforce your IP rights, right? You have to be very, very attentive. Then ensure that you use non-disclosure agreements with whosoever you enter into a contract with, so that they don't end up selling out your sensitive information in the course of doing business with you, right? Implement security measures such as use of watermarks and other anti-counterfeiting measures, right, in your product. Try and do that. Copyright, you have to put all these measures into place, and please seek legal advice. I mean, this workshop is just to give you an idea of what all this is all about, but you do not just have to wake up in the morning and open your chat GPT, open your any AI tool and start typing, oh, how do I register my trademark? Or how do I do this? Or how do I do that? You need the services of a lawyer. You need your legal practitioner to advise you on the recent happenings, any developments in the law and regulation. You need to be advised. And you can do that on your own. You can't just not wake up in the morning and read on the internet. You need to be advised legally. So please, let's put that into consideration. And yeah, before I close, I said something about passing off. So there are times that you don't register your trademark, right? But you've used it for a very long time in the course of business. Maybe you've not gingered yourself enough to register that trademark. But the thing is that you cannot bring that defense, or you cannot bring that enforcement under the Trademarks Act. No, 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 no. You can't do that. But you can bring it under tort. It's a tortious claim, which means I have been using this mark for over 15 years, for over 10 years. So you cannot just wake up in the morning and just come and use my mark. You understand? So you can take the matter to court, Federal High Court or State High Court. But in terms of passing off, I would advise Federal High Court. Now, what happens? You cannot come under the Trademarks Act, remember, because you've not registered your trademark. You don't have a certificate of registration, so you cannot do that. So what you now do is to come by way of a tortious claim of passing off. That, look, I have been in use of this for a very long time. You cannot just come and use it now. You understand? So that's how it works. Okay, so that's how it works. And passing off gives you the ability to protect that which you've used over a long period of time, right? But that does not mean that it's not subject to legal battle and use it. So passing off will come in handy. Okay. So if you're not satisfied with the decision of the court, so everything does not start and end with the Federal High Court. If you're not happy with the decision of the court, you can now appeal to the Court of Appeal, and God be with you. You can appeal to the Supreme Court if it's not still favorable. But I mean, that will take years, So in conclusion, right? In conclusion, you have to register and protect your ideas and your business features. Features is very important. Ensure you conduct regular audits and audit to identify and protect your assets. Implement IP policies and procedures when dealing with people and contractors, and monitor and enforce your IP rights against infringement. And please stay up to date with IP laws and regulation. And also, well, I think we say thank you for listening. And I hope I was able to touch on everything you might have thought about. Thank you very much. All right.
Thank you so much for that very insightful presentation. So I'll read the first question, and the subsequent questions, maybe Yoma will come in and then read those ones. The first question from Temiloluwa says, does the registry issue a new certificate upon renewal? And are there procedures applied by the registry to confirm non-use before revocation?
Okay, yeah. So for the first one, yes, you'll be issued with a new certificate upon renewal because it will now start by renewal will now have the new date to which you've started your you've registered renewed your certificate, right? So it will now have that new date to confirm when the next 14 years would expire. So after that 14 years, you would renew it again. And for non-use, well, for non-use, it could come from an objection, right? It could come from an objection. It could come from the fact that you have to also prove that my product is out there. Because if you go to renew and they ask you about, okay, what's your Ayomi Day? I've not seen any of your stuff out there. What are you doing this for? What is it used for? And none is found. I mean, the registry has records because, I mean, when you are going to renew, you have to go with documents to show that, oh, this is how I operate. This is what I do. This is how we've been doing for the past 7 years. This is how I've been doing for the past 14 years. So within the first 5 years, as I earlier said, that the registry would kind of revoke your registration, your trademark, is the fact that when a review is being made to all of this, and you see like, okay, this one is just dormant, this one doesn't have anything around, and you know that your mark is online, you've registered it, you've applied online, right? And these are the things that they will use in order to see non-usage. So where there is non-usage, immediately it can be revoked. It could be from by way of application by another third party, or it could be by way of their own investigation that, look, this trademark is not active. So let me take, for example, CAC normally do what we call, you have to file your returns, annual returns. Now, in way that you fail to do that, your registration can be revoked. Just the same way, trademark registry has a way of doing their investigation to know which trademark is dormant out there. You understand? So that's how it is. Then, considering the duration of the full registration, what happens if another person uses one trademark? No, 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 no. You can't use it. It's not the person coming to is also applying. He's on a queue. You understand? He's on a queue. So if there is a kind of a conflict, and the registry will tell you, look, there's somebody else who has already applied, right? So just wait until the decision is made. You understand? So if somebody else uses that same trademark to come here, person has to wait because this one is being processed. And in fact, the registry wouldn't even accept it because it is something that is going to exist. So you have to go and look for it. There's going to be a conflict. You understand? So are there rights in law for such person who is already in the process? Yes, yes, of course. Of course, the law protects you in the course of in the course of doing that. You are protected, right? By the Trademarks Act. There's a provision that allows you to, while you're registering, no other person can actually use that trademark. For the meantime, until maybe for whatever reason it's not allowed or whatever reason. So you have your protection assured. Okay, so that's sorted out by the Trademarks Act. Okay, so all right. Please, Yoma, can you go ahead and read the questions?
We have another one
Okay.
from Damilola.
Yes. Yes. So
It
we're both
says,
registered. Yes. Yes, please.
yes. It said where both registered and unregistered trademarks have been in existence concurrently, what is the remedy for either? What's the remedy for either when discovered that both are under tort and under the act?
Oh yes. So where there is some kind of a registered trademark, which is under the Trademarks Act, and one that is unregistered, well, well, that is where the issue comes in. You know that equitable principle that says where there are two equities, the law prevails. So the person that registered first under the Act, right, which I'm sure could be a pity. The person that registered under the Act would have a kind of a priority, right? So there's what we call priority. There's kind of, we'll have a priority over the person that did not register. While it is sad that the person will come by way of passing off, what will also be considered is how long have you been using your copyright? I mean, the person registered and the person that did not register. The fault can be that of the registry, right? The registry can mistakenly register the same trademark over an existing one. So the first in time under the law, which was registered first, would prevail. So going to do passing off at this stage would not actually be of assistance to you. You understand? But let it be that when you registered the trademark, you applied, and then there was no kind of a conflict, and it was registered successfully, no opposition. So the person that did not register should take note that before this trademark was sent out there was a publication on the trademark journal for about 3 months. You're supposed to object. Understand? You're supposed to object. But also, I mean, going to by way of passing off, this is where you are actually going to bring out the claims. I'm talking about the person for unregistered trademark. You will have to bring out at what time, how long have you been using it, right? Before we now go into, it was registered. Why didn't you object? Why did you lie down and wait for this to happen? Lashes and acquiescence and all of those things come into play. So it's very important that while you register your trademark or you've not registered your trademark, you have to be very vigilant. Equity helps the vigilant and not the indolent. So that's what I can say to you. The Trademarks Act protects that which is registered under the Act. And for you that didn't register, going by way of passing off or thought, you need to be able to show that you've used it for over 50 years, 20 years, a longer period of time, and all of those things, right? But I can't tell you that that is definite. Okay, I can't say that that's definite. That's what I have to say. Yes, any other question? Mr. Damilola, I don't know. Have I been able to touch your question?
Okay. We have another question from D, and she says, how useful is trademark for a small scale business compared to big brands?
Sorry, where's that?
D, she says, how useful
Okay.
is trademark for a small scale business compared to big brands?
Well, it is because, I mean, even though you're a small SME, you need to register, right? I mean, I know that at some point in your decision making, you may want to upscale, but it is important because it what I was talking about was distinctiveness of your brand. You have to be able to put it out there to show that, look, even though I'm starting this business, this is what I do. That is the essence. So there is no classification of saying that, trademark is for big brands or trademark is not for small brands. The idea of trademarking is to distinguish your products from others, to show the customers or to people out there that this is what I do. So the effect of you registering for as a small scale is to protect that which you are going to do out there in the instant that you boom out there. So let's say, for whatever, as I use Ayomide, Abigail, and who again, and Timothy, they all started small, but there is a need for them to protect their cosmetics and their skincare. There's a need for Timothy to protect his hotel services, or even though he's a motel, there's a need for him to do that. So there is the act did not say, look, small scale, wait until you become a bigger brand before you register or protect your trademark. The trademark is to protect your idea, your innovation. That is what it does. Okay, so it's impactful because it even gives you an opportunity to show that you are very, you're very formal. I mean, you followed all the, yeah, you're authentic. Let me use the word, you are very authentic. So if you're applying for a loan, for a scheme, for a grant, and you present your business is trademarked, your company is registered, you stand to gain a faster approval. You understand? So it goes a long way to helping you in terms of your brand. And for whatever is worth, the the bigger brands can also register their trademark. They also have their own distinctive measures and whatever, you understand. So for small medium scale entrepreneurs, you have to do it, because I mean, if you're going out there for grants and loan, you have to show that you are authentic, that you are very legit. And in order for you to do this, it shows that you've registered and you have all the necessary requirements that will be needed. So that's it. Yes. Any other question?
Okay. Yes. Akonji says, what's the cost to do trademark?
Well, that depends. I wouldn't really give you a round figure, but I would just say, for what's worth, when you apply to conduct search, I'm sure search is 1,500, if I'm not mistaken. Yeah, search is 1,005, and your application, it just boils down to what the registry would give you, because the prices can change due to even the economy is changing. So all these things do change as well. So I can't give you a very specific amount, but once you apply, you would see that the prices also change. And it's once also, when you use the services of a legal practitioner too, you should know that you're going to pay for professional service. So that too we also have to put into consideration. But I would advise that you keep up to, like, 300K, 250K for all of this. Even though, if in the case that may be more, just let's leave it at 300,000 naira. I'm not scaring you, please. Right? Just keep to that amount to register a trademark. That's it. And please, another question.
Yes. So if you have any questions, instead of raising your hand, kindly put them in the public chat. Thank you. So the question here, please, can I register just a name that I coined as my brand name for my trademark? That's
Yes, a name
the
is,
question.
yes, sure. That's it. A name, a picture, a label, a letter from your name, just something that makes you stand out. Distinctiveness is what we are talking about here. Distinctive. Yes, you can do that. Your name can be a trademark. Yes.
Okay. So Ayomide says, good morning all. Thanks for the detailed presentation. My question is regarding classes of trademark. If I sell
Yes.
skincare products, also do makeup, please under what class will my application or registration or trademark fall under?
Yes. So you're
Since the
good. So you're going to register under two different classes. Yes. So Ayomide, I'm glad you're paying attention. Right? This is your brand we're talking about today. So if you're doing skincare that makes the skin to shine, all you need to do is you put that classification under goods. And for the services that you render, you put it under services. So there is nowhere there, when going for registration, the registrar will not put both your skincare and your makeup under goods. No. The makeup you do are the services you render. So you have to put it under services. There's a classification for that, So under services, and while your skincare will go under goods. And I think your makeup would be under what should I say, business services. Business service, that's class 35. It's a business. When you make up, it's a business service. So it can fall under class 35, and your goods, your makeup, your skincare product will fall under goods. You understand? So that's it. Please, another question?
Yes. So someone says, how does the Nigerian Trademark Act compare to international trademark laws, such as those in the US or UK, especially regarding enforcement and protection?
Okay, so apparently the only thing we have in common with international best practices is the classifications of these trademarks, right? So for other countries, they have their peculiarities as to how you can enforce trademark. But I'm sure if we follow up other countries, they file a suit. Everybody files a suit to the court that has jurisdiction to hear these matters, and they present their claims, they present their exhibits. So if you follow up with cases of infringement online between these countries, between social media works and all of, you would see that they come by way of filing an application in court, filing their suit in court. And while their court system might be a bit more faster than ours, there is always that decision being reached. So our act just states procedure. Mr. Ubong Friday, can you type your question? I mean, because there are a lot of questions on this one, so we just follow up the ones that are being answered. Thank you. So as I was saying, the Trademark Act is just to show you what to do in terms of registering your trademark. It's more of solidifies your position when you go to enforce. You understand? In terms of court proceedings, we have court rules and other extant laws to help you in getting towards your case. But for other jurisdictions, right, they have their peculiarities in terms of filing an application, in terms of how you deal with the matters and how you enforce your right. But in all of this, enforcement is sure. In all of this, infringement is what the law would frown at. You understand? So we have our peculiarities, they have their peculiarities, but that the fact is their own system is faster. They can come by way of class action, enforce their, a lot of things. You understand? So that's it. There is no really a similarity in terms of how the court system works here with other jurisdictions. They have their own different way. But one thing you need to know is that you have to file in court to enforce it. Yeah. Any other question? Oh, and then yes, and for there are conventions, right? There are conventions. So let's say, for instance, that you find out that your trademark is being infringed in the United States of America. Someone else is using your trademark while you're in Nigeria, and somebody's using your trademark in Canada. I mean, we have to go through by way of international instrument, you understand? And it's another process entirely. And as well, perhaps, and it's going to be even more beneficial if you find out that that company has an operation here in Nigeria. You can file at the Federal High Court as well, you understand? So, but the international, you know, laws that apply, they apply to their own jurisdiction, you understand? But in terms of, let's say that there is an agreement between you and the company, or there is a kind of the company that infringed upon your rights is registered in Canada but has a business here in Nigeria, that could be a ground for you to go ahead and enforce your trademark, right? Can law firms also register its trademark? Well, yeah, of course, it falls under legal services. Yes, yes.
Okay, so someone says, are lawyers the only power of attorneys for registering trademarks?
So, the law did not say it's just lawyers, but you must be a registered agent. So, for you to register, just like corporate affairs, CSC accredited agent, it's not just lawyers. Anybody can, do that. So far as you have your NYSC discharge certificate, so you can show. Okay. So that's one of the requirements, but it's not just lawyers alone, but there is a requirement for you to follow to be an accredited agent or accredited trademark agent. Yeah. So you can try that out yourself, but you have to register and pay the prescribed fees, and then before you become an accredited agent. All right. Next question.
Okay. Someone said, if someone wants to register a name and logo, will he pay separately for them?
A name and a logo. Well, it's a representation which you want to use. You don't pay separately for them. You just, the representation you want to use, you can use it. So I failed to mention this, that if you want to register your trademark, right, and you want to use colors, let's say I think let's use red or blue for an example. You can decide to say, look, register the colors of these colors for my logo, my name, or my insignia using just red and blue. There is no guarantee that if there is any other color that comes up subsequently in yellow and black, that it would be protected. So the only time you would see and you say there is an infringement is if there is a red and blue on the insignia. You can now call that an infringement. But what I normally advise people is when you're registering your trademark, please do not limit it to the colors, right? Do not limit the colors. So just register it based on, without any color specification, or use black, because if you use black, it covers all any other colors in the world. You understand? So there will be no, oh, he was using blue, I decided to use yellow. There is no similarity. Everybody knows that your own is blue, and when they see my own is yellow. So we don't want that news and story and drama. It's best that you use a specific, or you register with that limitation, or you use black color. So that is it. But for your name and logo, you can just, it can be one trademark. You don't need to pay for two. They can be a trademark, okay, but just that is in one application. You don't need to apply twice. Say, I want to register my name, I want to register my logo. No, one is okay. Yes.
Okay, we have another question. She says that someone, I believe, told her that it takes 6 months after your name being published on the journal for you to get your certificate. Is that true?
Okay. This one, well, I don't, no, I don't agree with you on that. Now the problem is, it is prescribed that it should take just 3 months, right? It's just to take 3 months to publish these names, right? But there are times that holidays can come into play. There are days, public holidays, breaks and all of those things. So it ends up in enlarging the time. But it is believed that this publication is supposed to be made 3 months. In 3 months, those 3 calendar months, you are not to do anything. You just have to wait and look and watch to see if there is any opposition. But um, I don't think it takes up to 6 months. It doesn't take up to 6 months. But if there is any form of opposition while that is there, yeah, it can take longer. It can take longer because it's been opposed. But if there is none, it doesn't. But the thing is that all of this back and forth can take up to 12 to 18 months. Your registration process takes up 12 to 18 months. But just know that once details is published and there's no position, you just know that you will get your certificate of registration within 3 months. That is how it's supposed to be. But for any reason that there is any back and forth, it can extend. That will take even more than 6 months. You understand? So that's how it is, Elsie.
Okay, so David says, what available ADR do we have?
Oh yeah, David, my namesake. Yes. So yeah, so we have alternative dispute resolution include, we have arbitration, mediation, reconciliation, roundtable discussion. And the one that works, the most is mediation. Courts in our jurisdiction even would refer a lot of people to mediation, because you see, arbitration is like a court system itself. It's like a court process, but it doesn't really involve those formalities. It's the appointment of arbitrators. You appoint your arbitrators, and it's subject to agreement of parties, and it's normally used by people who go into contractual arrangement. But for mediation is what would work for SMEs, startups. Come on, you need to use mediation, because the cost that is involved in arbitration, well, it's high, but the thing is that it's faster. So we have arbitration, we have mediation, we have reconciliation. Yeah.
Okay. Oye Boyke Chidera says, what a wonderful workshop, David. Who are the authorized agent that can deal with the trademark registry?
Person that has been designated as an authorized agent by the trademark registry. So you have to apply for it. You have to, just like being a CSE agent, which you applied for it, you have to apply and be given that certification that you're an authorized agent. That's the same that goes to trademark as well. Yeah.
Okay. Ayomide says, a follow-up question, please. Since the registration will be under two different classes, am I going to pay the filing and registration fees differently, or one payment covers both classes of registration? Thanks.
Yeah, it covers both classes. You're going to pay the prescribed fee, because the registrar will give you prescribed fees. You will not say, oh, once you're registered for your goods, come, let's start all over again, register for the services. No. You pay for the prescribed fees, and if your the goods and services have, they are different, right? You pay for. So let's say, for example, pig milk are into goods. They pay for goods. You not see that they do telecommunication services. They don't do educational services, right? They can pay for. They don't do advertising services, so they only pay for the goods which they sell out there. For you that wants to do goods and services, you will pay for goods, and your unique what do you call it, makeup services, you also pay for it, because everybody wants to know that your midday classic makeup service, makeup and stuff, they have to know that you're the authentic one, you understand, and your products were authentic, so you will pay for both the goods and the services, but it's under one registration, you understand. It's under one registration, and it's something that will be determined by the registry. Yeah.
Okay. Elsie says also, is it possible for your trademark to be declined after this period?
Well, as I
Registration.
said, yes, if there is an objection being made and it's ruled that it doesn't qualify to be registered, it could be declined. But if you feel that there's no ground for which the registry declined your application, you can appeal to the registry formally. You file your complaint, and if you're not satisfied with what the registry is giving you, you appeal to the Federal High Court to say that your trademark meets all the criteria needed to be registered, and you do not see the reason why it wasn't registered. So yeah, it could be declined, but then again, you could also appeal within that month if it's not on any of those grounds, right?
Elsie says, how much is the registration? I think David has answered it.
Yeah, we've answered that. Yes.
Um, Chinedum says,
Yes.
please, when
Yes.
filing
Yes.
under different classes, are you going to be assessed and pay separately for each?
Yes, so your business will come on under either goods or services, or both goods and services. So you have to choose the one you want to do. You can't do 15. One company can actually do up to 10 classes, can do up to 10 classes of goods and 3 classes of services. Yes, you can do that, but you're going to pay separately for each classes. Yes, definitely. You pay separately for them.
Okay, Temiloluwa says, can one apply to the registry to amend or edit a trademark, or does amendment require a fresh registration?
So, well, you can, so for that one, when you have to amend your trademark, I believe, though I've not seen it done yet, but I think it's something you can actually apply to change, right? It comes with its own fees, comes with its own peculiarity. You understand? We can apply to just make a minor change to it, and yes, it will still go back to being so the registry will see the changes made, but it will still go back to being published again for opposition, because you've made a very distinctive change to that stuff, right? Although it will not go back to starting the application and blah blah blah, but if the registry feels it's necessary to publish it for the public to see, given the amount of change made, yes, it will be published again. An objection will be called, and where it is altered, you'll be given where there is no opposition, you'll be given a certificate to read that new changes you've made. I will not say it's a new application, but it has that process. Yes, so that's how it is.
Okay, Timothy says,
And
after getting the acceptance letter, can one make changes to the class or owner?
hey, Timothy, if you've made changes and you want to change again, you will have to pay for those changes you've made. Understand? The registry, it will take a long process though. That is why it's very advisable for you to consider all your steps before you go into the higgy haga of starting to apply and make changes. For the owner, no, you can assign right? So trademark is something you can assign to another person by an agreement. You can assign such and inform the registry that, look, I've assigned my trademark and right to usage to David, and David can also use my trademark, right? So once you want to do that, it has to be in writing. You have to, notify the registry. You understand? So in that regard, Timothy is offline. Anyways, in that regard, um, any changes you want to make, you will have to pay some prescribed fees, right? And this time around, it will be left to the whims and caprices of the registry to say, okay, I want to publish. I have seen that you've made so much changes, and it's very obvious. So we are going to have to, publish this. They can't do it in hiding, because whatever changes you've made can actually cause some issues, you know, with, or maybe interfere with another person's trademark. You understand? But I won't say it's a whole new process. It's just to make some changes. Yeah. So, well, gifts. As I said earlier, the prices of cost of things have changed. So it's upon your application that you will know how much you'll be charged. So I cannot give you a figure here, and you quote me, you go to registry tomorrow and said, David Ekanem said this thing is not supposed to cost more than 50,000. What are you doing? So please, the regulatory authorities have their might and ability to make these changes. It's not me. Okay. Yeah. So any other question?
Is there any other question? Because you're about to end.
There was Ubong was typing, I don't know, and he's still typing. Same with Nasiru.
Nasiru.
Yeah, they're both typing, so I don't know.
Okay. Here's a question. It says there is a legal tussle before Federal High Court between Coca-Cola and Pop-Cola Company.
Okay, says any concerning concerning the,
So he's saying there's a legal tussle
okay,
in court at the Federal High Court between Coca-Cola and Pop-Cola concerning the issue of trademark after they have registered. So what caused the problem?
Okay.
If you go and
So,
read, you have to read the case.
That's the thing. So I mean, this gist is out there, and in as much as I would love to have to give the gist, I've seen Mr. Nome has turned on his camera to tell me it have to. It's not my fault. So just a brief one, Mr. Bong, right? The issue here is in terms of the name, right? Coca-Cola is contending that, look, this thing is infringing on how we provide our product, and Pop Cola is coming with the same, situation. So the whole thing goes into the fact that you cannot use. I've existed. I've been using this. It's an infringement and all of those things. So that's how the tussle. Okay, so that's just the tussle that we are looking into, this issue of something being identical. And I would cite the case of, the case of International Tobacco and others, and BAT. The Supreme Court reiterated Section 16 of that act, of the Trademark Act, as to registration of a trademark in whole or in part with limitation to a specific color. That's what I was talking about. Must be taken into the consideration by a tribunal or court for the purpose of determining the distinctiveness of the trademark. The court held that the use of colors, right? The use of colors in a registered trademark is not merely a decoration, but is an essential feature of a trademark for which you, as a proprietor, should be entitled to have exclusive use. Coca-Cola and Pop Cola are contending the name, right? So it's something you have to put into consideration when you're registering. It's something that the registry will also have to put into consideration. You understand? And for gifts, for you to learn from this tussle, the fact is that you must always be attentive. You must always be very what should I say? Alert, right? Alert as to what is happening, so that you don't also end up fighting with Coca-Cola when you want to also bring out your own soft drinks. You understand? So So Ubong said mine is his contribution or an answer to a question. As a nested surveyor of a brand, um, uh, business contributes largely to your business valuation. Okay, it was just a contribution from him. But Nasiru, I would have really loved to give the full gist of the story, but I've been told I'm out of time. So I was supposed to use 60 minutes, but I've ended up using 94 minutes, which I must apologize to Mr. Nome, for my hands are up, so I'm sorry, but it was an interesting day to, have this conversation with all of you. And please, gift, it's very important that you pay attention to, the things you register, right? As I earlier said, and be sure that when you register, opposition there is no kind of a conflict with what is already exists. So conduct your search. Don't wake up in the morning and go and put it out there. So let the search be done and all of these things so that you don't have a tussle in court, because Coca-Cola and Pop-Cola will always continue to fight till whenever they are tired. You understand? So can I say thank you everybody now, or Mr. Nome? What do you say?
Okay, so just before we wrap, I know that many of us may still have a lot of questions. Now we've attached a link to our WhatsApp group. So from time to time now, normally on working days, we normally close. We normally let me say close the group for just admins. That's to talk, because we don't want people to be disturbed during their work hours. But then during the weekends, from Fridays through to Sundays, we leave it open so that we can have discussions on the group. You can send in your questions, or whatever findings that you're having, that can contribute to what we are learning as well. So kindly do join our WhatsApp group, and of course David will also be there to answer whatever questions he can when he can. But as well, definitely organize. What we'll also do is organize a separate workshop that will basically be a Q&A, so that during the week or month or whatever it is, you can gather all your questions, and then we can have a more interactive exchange. But I really think that this workshop has been really exciting, very informative. I've learned so much. Yes, so Gift's asking, I want many of my friends to contribute. Can I send it? Yes, please. You can definitely send them the group link. But what I would rather say, maybe Yoma would reach out to you, Gift, because before we want people to join the group, we would like to get to know who they are exactly, so that they don't get lost in the group. Is that okay? So we'll forward exactly link to you. But yeah, you can share the group with your friends. This has been an amazing.
So one last thing for Nasiru. So what you should know, that the gist of all this tussle was about a ribbon. You know that black thing that surrounds the Coca-Cola bottle, Pop-Cola. That's what Coca-Cola is contending that, look, you're also using our ribbon to advertise your work, which means your thing. They are saying that it looks like our own our own product. So that's what they're contending, telling them to stop. So that's the whole thing. So ribbon, that's what I was saying. Once you want to register your trademark, you have to register as to all the ingredients, the kind of colors, the kind of marks. You have to put them there and say, this is mine. Don't come near it. Don't approach it. You understand? So that's all the gist. And that is what is before the Federal High Court, And as of recent, I think the Federal High Court just gave a kind of an interlocutory order, an injunction saying everything should just Popular should halt on distributing their product that has that revised ribbon. So that's the whole gist. So everybody should just take note of that. And Mr. Nome, thank you very much for giving me that 1 minute to say that. Thank you.
Thank you so much for that insight. Someone was asking if we will get the recordings of the workshop. Yes, the recordings will be made available on maybe we'll put the link in the chat soon. But basically, ramen.legal/workshops. So the same link that you use to register for the workshop will have the recordings also listed there. And you can also watch the previous workshops that we've had if you weren't able to attend those as well. And also the slides, I'm sure we'll work out with Mr. David to make the slides available to all of you, especially those within the WhatsApp group. We'll be posting it there. And we'll also send a link out via email. Okay. Yeah, so I want to use this opportunity to first off thank every single one of you for joining our workshop today. We were aiming for an hour 30 minutes. I think we've just elapsed just a bit outside that time frame, but I'm excited because it's been a very engaging and exciting one. And I want to thank Mr. David Ekanem for giving us his time and sharing his knowledge and expertise with us. He has a wealth of information and knowledge and experience in this field, and we definitely look forward to engaging with him a lot more. Of course, if there's any questions that come up, you can always drop them on the WhatsApp group, or you can send us an email at community@ramen.legal. Okay. Thank you guys so much for your time, for spending time with us, and thank you, Mr. David, for sharing all that you shared with us.